nope, that document says no amputation, and therefore that's legally what has to. That's not what you mean. Hi, Jeff Marsachi, the Plain English Attorney, and welcome to the video. Today we are going to review the Adulting Starter Pack for estate planning. Now, I have a lot of clients that are our trust clients, so they understand about estate planning and trying to avoid probate and all that other stuff. But something that typically happens when their oldest child turns 18, and usually they're sending the kid off to college and the university's requesting medical records, or they're trying to get medical records for their child for some other purpose, for a new job or whatever. And then suddenly they go to the doctor's office and they're saying, no, we can't give you those records. Well, what are you talking about? Your child is now 18 and therefore their medical records are covered by HIPAA. We cannot give it to them. They have to request them. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Okay, so this typically starts off the chain reaction of, all right, we need to do something because yes, our child is a legal adult, but at the same time, we're still helping them out. Look, for most states, 18 is when you're an adult and a whole bunch of rights as well as responsibilities kick in. And at that point, though, the parents are not typically done, I don't want to say raising their child, but helping their child. And so they can't legally get access to these things. So they contact my office, and what we usually end up putting together for them, for their child, really, they kind of become our clients too. We put together a healthcare power of attorney and a financial power of attorney so that they can do these things that they have been doing all along. They can help their child do certain things, but they're not really completely taking over. It's that transition period. All right, well, what happens when it's a few more years down the road? Either they're out of college or they're established in a job and they're making their own money, and maybe even there's a spouse or potential spouse or partner coming into the picture. That's when it's time to get serious and start adulting. All right, so what do they need to do for their estate planning? Well, this is where really the starting paperwork is the big 5 documents, and I'll cover a little bit on each one of them. So the first one that everybody always thinks about, it's that last will and testament. All right, so this is where do your assets go when you pass on? Who would be the executor handling things? Nobody wants to think about dying young, but look, it's good to just have this in place if you have enough assets that you care about where they want to go. Now, prior to that, typically there isn't a lot of property that the young adults have. The default, and you have to check your state laws, but the default is, okay, it goes to the parents if you don't have children of your own or you're not married. And that's kind of good enough for, like I said, for college or those early working years. But then suddenly when there's someone else in the picture or there's a child in the picture, it becomes a much bigger thing. So that's where the last will and testament comes in. So you can choose who you want to be the executor, who's going to carry out these wishes with the probate court. Now, if you want to avoid probate like your parents did, that's a whole other thing. But most of the time, at least not until they're either married or there's a child in the picture, are my clients going to go to that level, or at least think about going to that level. So the last will and testament, even though it means probate, is usually good enough. So they're laying out who's the executor, and we recommend one person at a time. And then they're listing who gets their estate and their property in the will. So if it's still the parents, well, okay, list the parents. If it's, no, my parents don't need or want my money, I want a sibling, or I've got a boyfriend, girlfriend, or whomever, I want them to receive certain things, that's where it goes into the will. So the will is kind of like that base, very basic, like I said, adulting starter pack document for estate planning. It's the last will and testament. Second big document we've already really mentioned, it's that financial power of attorney. the legal phrase, usually it's a durable general power of attorney. So this is empowering someone else to make and assist with financial decisions. Typically, by the time we're at the Adulting 101 starter pack, it's like, okay, they're handling their own finances on their own. They're making their way in life. But what if there's an incapacity? Or what if they just need a little bit of help with something big that comes along? They may still want their parents involved. So it's important to have that financial power of attorney so that they legally can go to a bank, go to a financial institution, work with governments. God forbid it's something like a disability. They've got that document that says, here, I'm the person who's in charge. Now, this is also a good point to talk about how a lot of my clients' children are like, well, can I just have both my parents in charge? No, because that's kind of doubling the paperwork. You want one person at a time. And it's very common for people to put one parent and then a second parent in that second position, third, and maybe even a fourth, so that your parents are in the documents, but it's only one person at a time. So financially now, anything that's in your name, they can take control of and handle things financially for you. Third big document, this is the healthcare power of attorney. In a crisis, this may be even more important than the financial stuff. So this is where you have, again, one parent at a time. They're in charge of making healthcare decisions for you, but they're also empowered to collect information like medical records and things like that. They can assist with getting things done if you are in some kind of health or medical crisis or an accident. So you're always going to be in charge of your own health decisions as long as you are conscious and able. But you're appointing this person to make these healthcare decisions for you if you can't, but currently do things like gather medical records and information and speak with doctors. So that's the third big document. The fourth big document, this is more of a long-term thing if you really are in a crisis or an accident, and it's a nomination of conservator. Well, what's the nomination of conservator? Basically, it's you making recommendations to a court. If I end up in a position where I am unable to handle my own affairs for a sustained period of time, this is the person that I want in charge. It's kind of like naming your own guardians as an adult. Prior to turning 18, the parents would make a recommendation because legally you're not an adult, and therefore they would be the ones trying to choose, well, if anything happens to me, here's who I want as guardians. And this is something that may come up. This will be the bonus document if you do have children. We'll talk about that in a bit. But if you're naming your own guardian, it's the nomination of conservator. Now, in North Carolina and maybe some other states, guardian and conservator, the process may be almost exactly the same, with the one exception is if you are a legal adult, they just have to prove that you're incapacitated. And usually a court's going to just take documentation from a physician saying, yes, they cannot do these things and therefore they're incapacitated. And then the court can go to, all right, who's going to be the best person? You making that nomination, you choosing who you want becomes critical. Now, a good thing in North Carolina, but may not be for all states, you can choose a conservator of the person and a conservator of the estate. And just to keep it uniform across the board, if you're doing a financial power of attorney, naming your conservator of the estate to be that same exact list of people just makes sense. And the conservator of the person, using the same exact list you used as the healthcare power of attorney, that also makes sense. So that's the fourth big document. What about the fifth one? This is a very specific healthcare and medical document called a living will. North Carolina calls it a declaration of a desire for a natural death. Now, you can get into all of these very specific decisions. If I'm in this condition, I want this to happen. If I'm in this condition, I want this to happen. I often look at that as more of a straitjacket on the person you're naming as your healthcare power of attorney. So the, quote, the old living will in North Carolina, is a very simple document, and it states, if I am in a persistent vegetative state or I am terminal and incurable, doctors, here is what you do. And usually that decision is take me off the life support and the artificial nutrition and hydration, or don't, or just leave it the way it is. So it's really to take that emotional burden off of your healthcare power of attorney so you make that kind of final end decision yourself. Well, why not put all of these other things in there? Just to give you the example, and there's this document out there called the 5 Wishes document. I mean, okay, it's good. It's better than nothing at all, I suppose. But it really isn't just, okay, here are my wishes. The way they structure that document, it's actually a signed legal document with witnesses and making sure that, okay, no, this has legal effect. And I had a client say, well, I don't need a healthcare power of attorney living will. Here, I've got this document. They put in no amputation. I said, okay, let's talk about that for a second. What do you mean no amputation? Oh, well, I'm a type 1 diabetic, and if they're ever going to take off an arm or a leg, I'd rather they just let me go. Okay, but no amputation means no amputation. If you get an infection in your pinky right there, you're unconscious, you're in a coma or something, and they could just amputate right to that knuckle, and you could live for another 20 years once you come out of your coma. Nope, that document says no amputation, and therefore that's legally what has to... That's not what you mean. So it's those kind of calls that can have a very strong unintended legal consequence. Whereas if you have a healthcare power of attorney and you leave that type of decision up to them and you talk to them, here's what I want. If you said, okay, well, if you're going to take off an arm or a leg and an amputation, I'd rather you let me go. Okay, they understand that. If you're in that coma and there's that little infection, they're going to go, well, it's not a whole arm and a leg. Obviously, you would want them to do that. But your legal document says no amputation. So that's why I really tend to have, in combination, you've got your healthcare power of attorney and your living will. You're taking the emotional burden of that final withdraw life support and let you go decision off of your healthcare power of attorney. That's the importance of the document. Not so much for very specific items. Now, this varies from state to state. I really recommend, as a practical matter, if you trust your healthcare power of attorney to make these decisions for you, leave them the authority to do that, except that very last emotional burden one. So that's the 5 big documents. What is the bonus document? All right, the bonus document is if you already have children, then you want to nominate people who would be guardians for them. Now, going back to what I said about healthcare and financial power of attorney agents, you do want one person at a time. People tend to automatically think, I want a couple to handle it. Well, look, there's a 50% divorce rate out there. Do you really want to roll the dice and name 2 people as co-guardians? No, you don't. Most of the time when people say, oh, I want my brother and sister-in-law to be guardians, what they really mean is, no, I want my brother. My sister-in-law happens to be there. So you just name your brother. And in some cases it's, well, we've been friends and family for many, many years. Even if they get divorced, I would trust my sister-in-law. Fine. Put her second. Don't put to them together, so you may end up nominating 2 divorced people to be co-guardians. That just does not work out. So one person at a time. So this is where you're nominating people who would be raising your children. And look, if you're at that point, you at least need the 5 basics and that guardian nomination form. But that's also the time to start looking at revocable living trusts as a way to long-term potentially hold wealth. If it's, okay, I haven't accumulated a lot of assets, but I've got young kids and I'm getting a large life insurance policy. Well, you want the life insurance to go into something like a revocable living trust so that your trustee, that same financial person, can end up managing that money for your child or children until they reach an appropriate age to actually give them control of it. And it's not going to have to be supervised by a court the way a last will and testament was. Now, if you want some good information on all of these documents, but particularly with probate and revocable living trust, check out our free course, the freetrustcourse.com. Go ahead and get access to that and you go through that information and then start thinking about what you want to do. And are you going to get the basic 5, the adulting starter pack, or should you start looking at something a little more appropriate and stronger in estate planning like a revocable living trust? So I hope you found that information useful. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.